This is a scripted video, so if you see me glancing down at any moment, it's me scripting it or reading from the script because I want my points to be clear and I don't want to repeat myself like I have been doing in past videos. So without further ado, let's get on to the video. Hello everyone, and welcome back to another riveting breakdown of an abortion bill. This time we are going to Missouri. Good old Mizzou. They have recently passed a bill through their Senate regarding abortion. This is not a law as of yet. Please keep that in mind. On the other hand, it did land on the governor's desk on May 17th of this year. I will be keeping an eye on it and giving updates. For those of you wondering why this is not a reading of the bill akin to the readings of the Georgia and Alabama bills, it is due to the fact this bill is 30 pages in length. That would be a whopper of a video. So I will be highlighting the key points everyone seems to be concerned about, and those are: number 1, funding; number 2, any clauses for child support or abortion payment from either parent; number 3, rape and incest exemptions; number 4, physical danger exemptions; 5, mental health exemptions; 6, deadline for an abortion; and 7, any adjudication such as prison time or parole of any kind. In order for any of the above to be addressed, the bill must have it listed in black and white and spelled out clearly. For example, incest and rape must be clearly in the bill for it to be considered an exemption. Otherwise, I will say it is not in the bill. This list will be included in all future bill breakdowns when the bills are longer than 10 pages. I will also provide screen caps of the bill with the mentioned points highlighted. If there are any points you feel I have missed, please feel free to leave them in the comments and I will address them. As always, the link to the PDF of the bill is in the description. Tax credits. Section A135.630. There was an added clause that kicks in on January 1st, 2021 that is on the screen. This is the third since January of 2007. The clause has guidelines that must be met in order for the credit to be applied. The credit can't be more than the state tax liability for the claimed credit. It can't be more than $50,000 per tax year. It can only carry over to the next year. The contribution has to be $100 or more. This section also defines the power of the director. The director has the final say over which facilities can be called pregnancy resource centers. They have the ability to set guidelines on how to qualify as said facility. The director can also set guidelines as to how a taxpayer can determine which facilities can be called pregnancy resource centers. Such centers can also refuse contributions. There are also guidelines on the identification of the contributors. 188.010. In this section, they define the following terms. It isn't until you get to section 188.017 that you get to the title, Right to Life of the Unborn Child Act. You'll notice a lot of this section is in bold. I did not do this. As a matter of fact, these bold entries are the proposed language. As you can see, any physician performing an abortion not done for medical emergency reasons will be charged with a Class B felony. A Class B felony includes manslaughter and can carry with it a minimum of 5 years in prison and up to a maximum sentence of 15. They also risk the chance of losing their license to practice medicine. Their mother would not be charged with anything, not even conspiracy. In section 188.026, they directly reference Roe versus Wade. They state that information of fetal development and the effects of abortion were not known at that time, which they were not. However, they go on to include that life begins at conception. They go on to list a history of banning abortion in Missouri. It isn't until page 7, line 41, that they state when a heartbeat can be detected by different devices. They continue on to describe the viability of the fetus and when it can be determined when the child can survive in the womb. They also go through the entire gestation of a child. Then they go into case law and more abortion history. Along with the gestational period, they go into risks of the mother having an abortion at different stages of the pregnancy, stating the later stage the abortion, the more risk it poses to the mother. On page 13, line 247, they clearly define their interest: protecting the unborn, preserving the life of the unborn, pushing birth over abortion, respect for all life from conception on, keeping the unborn safe from harm caused by abortion, preserving the integrity of the medical professional community, ending the ambiguity of the law, reducing risks to the mother, lessening health system burdens and other fiscal burdens as well. 188.027 has your medical emergency exemption. It also says an abortion can be performed only with the consent of the pregnant mother. It also has to be a minimum of 72 hours before the abortion. It also states the doctor has to inform the mother of any and all risks of abortion. This includes images of developing fetuses / children and the psychological ramifications that can happen due to abortion. The mother has to be given a list of locations that are sanctioned to give abortions. During the informed consent section, it was added for the physician to give the mother reading material as to when the child they are carrying can feel pain. Page 17, line 119, starts the section of carrying the child to term and putting the child up for adoption and helping the mother with welfare programs if they decide to keep the child. The section before that covers the obligations of the father in terms of child support and establishing paternity. Page 19 puts safeguards in place in cases where the woman is coerced into having an abortion. Okay. Page 21 is where we get to exemptions for rape, pregnancy due to prostitution, pregnancy due to porn and incest, but, and there is a but, only if the person is under the age of 18. This can only happen if not only the minor consents, but a legal parent or guardian must consent as well. Consent from a legal adult isn't needed in the cases listed above if the child is emancipated. It goes on to listing to petitions of emancipated minors. 1.88.038 goes into making discriminating against the mother, no matter race, ethnicity, the poor, etc., is illegal. They go into abortion statistics. Page 24, line 19 says you can't have an abortion just because the baby isn't the sex you were expecting. Then it hits a feminist beat with female inferiority. The next two paragraphs make it illegal to abort the child if it tests positive for Down syndrome. Page 25 goes on to say it's illegal to perform an abortion if the physician does not have malpractice insurance. Then there's this gem. For the purpose of this section, quote, tail insurance, unquote, means insurance which covers the legal liability of the insured once a medical malpractice insurance policy is canceled, not renewed, or terminated, and covers claims made after such cancellation or termination for acts occurring during the period the prior medical malpractice insurance was in effect. No abortion facility or hospital shall employ or engage the services of a person to induce an abortion on another using any drug or chemical or combination thereof which may cause birth defects, disability, or other injury in a child who survives the abortion. If the person does not have tail insurance pursuant to this section, except that the abortion facility or hospital may provide tail insurance for the services of persons employed or engaged by such a facility or hospital, which is no less than the coverage amounts and duration set forth in this section. It takes until page 26 and section 188.056 to state that an abortion cannot be performed at 8 weeks or after. Any doctor performing an abortion after the deadline time limit will face a Class B felony. The mother of the child will not be prosecuted for conspiracy. In section 188.057, they say the same thing again, but give the deadline / time limit of 14 weeks. Is this not in direct conflict with the section before it? Section 188.058 says 18 weeks or later. Section 188.375 goes into late-term abortions. It states much the same as the sections before it, giving only exemptions for medical emergencies. Again, the doctor is held legally accountable, but the mother is not. In late-term abortions, the physician must do everything they can to preserve the life of the child unless it means the mother is in grave medical danger. Then and only then can the life of a child be forfeit. Once the child has been aborted in the 3rd trimester and is alive, someone in the medical profession must be present to give care to the child. Any professional caught breaking these provisions can face a Class D felony, which includes fraud and 3rd-degree domestic assault. The sentence for that can be up to 7 years in prison, 1 year in jail, and a fine of either $10,000 or twice the amount of the physician's financial gain. Again, the doctor stands to lose their license to practice medicine. On page 30, there is a trigger clause. This means if Roe v. Wade is overturned, abortion will be illegal in Missouri. Okay, This is a convoluted one, to say the least. They do have an exemption for rape and incest and the like, but only if it's a minor. Protecting minors is never a bad thing, but what about adults that are victims of rape and incest? They also include pregnancy due to prostitution and pornography, but again, minors only. This is very good. Child prostitution and pornography are not only skeezy, it's illegal. I have no problems with that. Adults in the sex industry should know the risks and take proper precautions, including access to the morning after pills. What keeps sticking in my craw is holding the doctor culpable, but not the woman getting the abortion. I believe she should be charged with conspiracy at least. She did go to the doctor for the abortion. They will give tax credits for contributions, but there's nothing in the bill that states that the state will foot the bill for abortions. At least I didn't see anything in there. I'm perfectly fine with that. The state shouldn't pay for your want to have an abortion unless your life is at stake and you can't afford it. I didn't see anything there against contraception or the morning after pills in general, only after the 8 weeks. But I think it's ridiculous. They think life starts at conception. This isn't the only bill I've read that states that. At least they gave it an 8-week time frame. Let's look at that. A woman is fertile for roughly 4 days of her cycle following her period. This would normally mean it would take 20 to 28 days to find out if they're late, depending on her cycle. At the extreme, some women have one more period after conception, which would push that to a minimum of 40 days. That's 5 weeks and then some before you even get an inkling of whether you are going to be late or not. It's 56 weeks on the high end or 8 weeks. That's still too close. I stick to my original opinion in the Alabama video. 12 weeks is more than reasonable to find out you're pregnant and weigh your options accordingly. Let me hear what you think in the comment section. Until next time, be good to one another.
As always, thank you for watching. If you like the content you've just seen, don't forget to hit that like button. We can continue the conversation in the comment section below. Any and all sources used for the video can be found in the description, as well as links to the blog and how to support the channel. As always, stay skeptical, never stop asking questions, and always look for the truth.